So the first one, domestic violence, that means that the person requesting the restraining order has to have a relationship that falls under Family Code 6211. So that means first degree or second degree familial relationship, or dating relationship, intimate partner. So that would fall under domestic violence. Now, if it's a relationship outside of that, so there's a table of consanguinity I can send out also, so you know which relationships fall under which. But outside of a dating relationship or a close family relationship, it would be considered civil harassment. And so that could be, for instance, a neighbor, a coworker, or niece or nephew. So with the protections are a little bit different. In the domestic violence restraining orders, there are orders also for custody and visitation, if that's applicable. There's requests for move-out orders, whereas in civil harassment, there would not be support orders or custody and visitation orders. Another type of civil restraining order will be an elder abuse or a dependent adult. So someone 65 or older could come to court and seek protection from being physically abused, financially, mentally, or emotionally abused, neglected, abandoned, isolated, or deprived by a caregiver of services to avoid harm or suffering. So because of the restrictions with the pandemic and everything, what was really important for our court is to remain open the whole time of the shelter in place for victims of domestic violence to come in and seek in-person assistance. For all other non-emergency issues, the court changed the self-help services to remote. So we would answer the phone lives, we have live chat, we have remote video conferencing. We continue to offer day of court services, but remotely, but we wanted to make sure that for victims of domestic violence, for people that needed emergency custody and visitation, emergency guardianship issues, or nowadays with the evictions, kind of being an emergency because of the pandemic and the different rules, the litigants can come in directly to the court to get services. So to give you an idea, when the customer comes in, and we call them customers, I should say, because although I'm an attorney, I work for the court, we help both sides, right? So we will help the person seeking the assistance and then also the person who wants to respond to their restraining order. So we'll help and in a neutral way, provide legal information, but not legal advice. So we can explain the law, tell them what to expect, but we're not going to be representing them in court. It's very different from a traditional attorney-client relationship. So what's important to note is that when people come in, we want to ask them, first of all, what is the relationship between you and the person you're seeking to restrain? And that will determine which forms we give them. And so the way our office has found it helpful is to provide people with the form packet that they need to fill out, along with a sample that walks them page by page through all the forms to make it a little bit easier to navigate, right? And then the thing that's really important is, as HaNhi mentioned, there is, if a criminal protective emergency order was granted, sometimes people come to civil court so that there's not a lapse, something doesn't expire, right? And they still have the protection. So we'll talk to them about when they file, they're asking for emergency orders that will protect them until the court hearing. Now, typically, the court hearing happens within 21 to 25 days, but because of the emergency orders, that has been expanded, so they could last 30 days or 90 days until the court hearing, depending on the situation. So if, for instance, the victim comes in and has children with the alleged perpetrator, the custody and visitation orders can be the temporary orders as well. And if those orders are for no visitation, the court is going to set a sooner hearing than for people that don't have children. So I hope that that makes sense. So what's really important for them to know is, yes, they can come in person, they can access our resources that way, and then we help them through their declaration to understand how to present the information to the court, because it's just a written declaration. There's not necessarily the opportunity to present evidence per se, but they can definitely include text messages or pictures, things like that. But what's really important in the declaration is to paint a clear picture for the judicial officer who's going to grant this temporary order within 24 to 48 hours. So it's a really quick turnaround time. for the restraining orders, temporary restraining orders. So that covers the domestic violence restraining order, civil harassment, different standard, right? And that is heard over in civil court. So in Santa Clara County, it's just across the street from the family courthouse. And the elder abuse restraining orders are also heard in civil court. So those are the things that I wanted to let y'all know about. And again, I can only speak to Santa Clara County, but yes, I would encourage everybody for other areas to look at the hotline, National Domestic Violence Hotline. So the number you should know is 1-800-799-7233, or it would stand for 1-800-799-SAFE, SAFE. And the website would be thehotline.org, and that would give you access to what locally is in your area. So the courts, as HaNhi said, have been proactive in making sure that people have access in a way that's safe given the COVID-19 protocol. So yes, there is a conference line they can call into. There is remote hearings video appearance. So that way they don't have to worry about having to find childcare, for instance, or, wear a mask. They could do it in where they are at and participate in the hearing that way. There is also domestic violence advocates are available to help them as a support person in court. And then similarly to what HaNhi said, we do have access to Vietnamese and Spanish in Santa Clara County are the most common languages outside of English. For anything else, we can order interpreters. And one of the silver linings through this is because everybody's used to appearing remotely, we have been really successful in accessing other languages through a language line. So are there any?
The voicemail and the individual who answered the phone was only an English-speaking individual. So those were barriers to access. In addition, there's just been significant delays. Everything takes longer. Court hearings were pushed out significantly. DV survivors don't just need protection in the form of restraining orders. I also represent survivors of domestic violence in their divorce cases, child custody cases, child support cases, and immigration cases, certain immigration cases related to domestic violence survivors, affirmative cases only. And in some of those instances, a survivor might need access to income or finances, might need an enforcement motion, and courts were not hearing all of those matters. So a lot of survivors were delayed in receiving any adjudication on their cases. Some are still waiting today, and some, we believe, who didn't have attorneys maybe stopped trying to access services. If they didn't have an attorney helping them, the barriers were insurmountable, and we don't know how many people are without help and services because they didn't even know how to access it. And I think there's just a very important distinction to be made for people who have attorneys and people who don't have attorneys. We do offer free legal services to low-income individuals in the Bay Area, but we can't help everyone. There's only 2 staff attorneys in the family law unit in San Francisco, and so, services can be limited even though we do offer free legal services. So, calls also went up recently, but, I looked at our statistics in preparation for this interview, and they completely vary from March to December. There was a significant drop in early March and up until June or July. Numbers went up in June and July. They went down a little bit in the early fall, and they're up again. So it really seems to vary. I agree that I think survivors probably had trouble accessing services by making a confidential phone call. But it does seem clear that the numbers are not consistent in terms of being up or down. So I think we just need to look at that maybe review that at the end of the year and try to come up with ideas around what was happening in the community and how we can best respond to that as legal service providers moving forward, since we're unclear what 2021 brings in terms of shelter in place. So we'd like to be able to help the members in the community moving forward in the most appropriate way possible during this pandemic. I think other ways in which the court system and law enforcement, in my opinion, have been failing survivors is we don't have adequate implicit bias training for bench officers. We don't have adequate implicit bias training for officers that respond to the scene in domestic violence cases. I think it's really important for there to be this kind of mandatory training for judicial officers and for all police officers. Culturally sensitive responses to survivors of domestic violence is critical. Some people who are undocumented are, of course, not going to feel comfortable sharing the details. Some individuals from different cultures are comfortable sharing details in a different manner than in another culture. And I think that the bias that survivors encounter when they enter the courtroom is significant and affects everyone's case. That's a long-term issue. That's not specifically a COVID issue, but it is significant, ongoing, and I think progress needs to be made if we really are going to help survivors of domestic violence in the community. I have to be honest, most of my cases are not prosecuted. My clients file police reports and no prosecution is ever pursued. My clients typically don't end up feeling that they have the support from the police department when they report TRO violations, or when they report domestic violence incidents and are seeking enforcement of some kind, whether that be removing the abuser from the household, an arrest, or a criminal case if that's what they're choosing. My clients don't typically report responsiveness from the police department in those respects. So those are challenges that I think we're seeing in terms of accountability. There's not necessarily a position that all cases should be prosecuted or that we're advocating in general for a criminal case to be open, but in the instances where a client expresses the desire to have a criminal case proceed, it is not always the case that they have the assistance of moving forward with a criminal case. And I guess last to add, I think the Family Justice Center model is wonderful, but some counties don't offer that. So again, just check in your county. For instance, San Francisco does not have a Family Justice Center, but we do have a variety of nonprofits that are all very interconnected and provide unique legal services in different areas of the law and in different fields. We have a wonderful relationship with the DA's office and the SFPD officers and the sheriff's office. We're all in communication with each other to best help survivors, but not every county has the same model. So it would be good to just check for each client to check, or each individual in a community to confirm.